Hi everyone, today I'm going to talk about evolution of law of torts in India. As a general rule, we can say that the principles of English law have been deemed to be applicable in India, and the Indian courts they do not follow each and every principles of English law, but Indian courts they follow it with the English law if it is in consonance with justice, equity, and good conscience. And there is very little tort litigation in India, we can say. That is because there are major reasons for the lack of tort litigation. So the first we can say is lack of consciousness about one's right. And second is the high cost of litigation. Third point we can say is undue delay in the litigation process. And fourth is damages awarded are very low. Let's see two case laws related to this. So first is in Shamsundar versus State of Rajasthan. In this, a widow had gone till Supreme Court to get compensation of less than rupees 15,000 on her husband's death, and it took about 21 years. The next case is Subhash Chandra versus Ram Singh. In a case of permanent disability to a child of 7 years, the amount of compensation awarded by the tribunal was only rupees 3,000, which was increased by the High Court to rupees 7,500 for permanent disability of a child of 7 years. And we can say in one area where the legislature has taken progressive attitude is that of motor vehicle accidents. That is, Motor Vehicles Act of 1988 does not require the payment of ad valorem based on value court fee. And for these cases, it has established claim tribunals which can follow summary procedure for expeditious settlement of claims in respect of accident cases. Now let's see the nature and definition of tort. So the word tort has been derived from the Latin term tortum, which means to twist. So we can say that tort is a civil wrong, and this civil wrong is other than a mere breach of contract or breach of trust, and is redressable by a action for unliquidated damages. Let's see this one by one. Now let's see tort as a civil wrong. So tort is a civil wrong. So it involves injured party and wrongdoer. Injured party will be called as plaintiff and wrongdoer will be defendant. In the criminal wrong, the injured party will be known as victim or sufferer, and who has done injury is the accused. And in civil wrong, the compensation will be in terms of damages, and in criminal wrong, the compensation will be in terms of punishment to the accused and damages to the victim. If in case of both civil and criminal, if that case is, in that case the remedies could be concurrently be available. That is, in civil action requiring the defendant to pay compensation, as I said before, and in criminal action they need to go through the punishment. That is, the accused will be punished for the offense he has made, and the victim will be given compensation by the accused or the defendant. Now, the next point is tort is other than a mere breach of contract or breach of trust. So, example we can take, that is, A delivers his horse to B, okay, for safe custody for a week, and B what he does is he allows the horse to die of starvation. So here B has committed two wrongs, that is breach of contract. He has broken the contract because he has allowed the horse to die of starvation. That is one point. And also he has not given the food to horse. That amounts to negligence from his part, B's part. So therefore the plaintiff can claim damages either under the law of torts, that is for negligence, or for the breach of contract of bailment. Okay, and he cannot claim damages twice here. He cannot claim damages under the law of torts for negligence and also for the breach of contract of bailment, but he can only claim either of any one. The next is tort is redressable by an action for unliquidated damages. So in tort we can say that tort is a civil wrong. So civil wrong deals with damages or compensation for the sufferer or the plaintiff. So here the remedy for the tort is in damages, and for the tort the damages are unliquidated. Okay. And for the breach of contract, as I said before, or the trust breach of trust, the damages will be liquidated damages. So let's see the difference between liquidated and unliquidated damages. So unliquidated damages are those which will be amount will be determined by the court, and liquidated damages are the upon the based upon the contract the amount will be determined, that is previously determined. So two parties will be there, A and B. They will determine some amount, and if there is any breach of a contract, then they have to pay the amount to the sufferer. But in case of unliquidated damages, tort is based on unliquidated damages. So here the case will be taken to the court, and the court will determine the damages that the defendant have to pay to the plaintiff. Okay, thank you.